7:30. We'll call the Marathon County Public Safety Committee meeting to order. We will start off with the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. We'll move on to number 3 of the agenda, which is public comment. I know that Chair Mask has asked that I give her the floor to say a couple words here, so I'll turn the floor over to Chair Mask.
Thank you. I just wanted to thank Supervisor Zhang for taking care of chairing the meeting today. I'll just be a participant. I had a collision with black ice landing on my left thigh. Nothing is broken, but I am bruised up like you wouldn't believe. So I'm just going to be sitting here with my leg up and ice on it and be a regular member again. Thanks again, Yi.
Thank you, and I'm hoping that you recover quickly so you could chair the next meeting as well.
I plan on it.
At this time here, I don't think anybody has approached the chair or the recording secretary, so the chair would deem that public comment is now closed. We'll move on to number 4, approval of the November 11, 2025 Public Safety Committee meeting minutes. What's the pleasure of this committee? Motion from Supervisor Opel, second from Supervisor Wilhelm. Any discussions? Hearing none, all those in favor signify by saying aye.
Aye.
Those opposed, same sign. The motion carries and the minutes is approved. We'll move on to number 5, operational functions required by statute, ordinance, resolution, or policy. We'll start off with discussion and possible actions by the Public Safety Committee. 5A, discussion and possible action by the PUBS. Okay, is there nothing for 5A, I'm assuming? Okay, so then we'll move on to 5B, which is the discussion and a possible action by the Public Safety Committee to forward to the County Board for consideration. We'll start off with 5B1, Sheriff's Office JAG Drug Task Force Grant and the Law Enforcement Drug Trafficking Response Grant. Who will be taking this? Sheriff Billup? Okay. I'll turn the floor over to Sheriff Billup.
All right, now we're on. New design. For those who don't know, the Sheriff's Office oftentimes receives grants or opportunities for grants that are non-competitive, meaning that we don't have to actually go out and seek those grants. They are just automatically given to us, and some of them are given to us historically. We receive them every year. You've approved these types of grants in the past, almost every year, and this is one of them. And then there'll be one additional grant. I'm gonna ask Captain Stefanik to describe what the 2 grants are, so we can hopefully get them moved forward to the board.
Thank you, Sheriff. The first is, both these grants are administered by the Wisconsin Department of Justice. One we've been getting since Survey 2011, surveying multi-jurisdictional drug task forces in Wisconsin. It is the JAG, Drug Task Forces Grant Award. The total grant amount that we applied for in the non-competitive grant is $44,446. That one has been approved and granted, so we are asking for an amendment to the budget to accept that grant money. The second one is the Law Enforcement Drug Trafficking Response Grant, also administered by the DOJ. It is considered competitive for what's available in the pot of money, but it is only open to multi-jurisdictional task forces in Wisconsin. For this year, we have applied for money through that grant to increase our capabilities for the storage of digital evidence and processing of that digital evidence, specifically very large hard drives. That type of evidence is involved in pretty much every case we work, especially drug cases where there are multiple cell phones seized in every drug case, and the storage capabilities of those cell phones is ever increasing. I think we're nearing a terabyte on some cell phones now, and storing evidence has become difficult and expensive. So we asked for money, $22,990 through that grant to buy multiple large hard drives and 6 computers capable of processing the digital evidence. And again, we have that's The status of that grant is considered in review. It has not been awarded yet. However, we have asked for a budget amendment to accept those funds should they be awarded.
Administrator Leonard.
Thank you, Acting Chair Zhang. I apologize. We have two memos that are actually in the HR, Finance, and Property packet on each of these that Jeff talked about. Your rules would require if you would make a motion to recommend acceptance of each of the grants should we be awarded the second grant. Your rules require those recommendations to go through HR, Finance, and Property before going to the full board anyway. My mistake, should have had those memos that Jeff did a great job. If you want to look at the HR, Finance, and Property packet, giving you all the same information he just gave you today. But the recommendation that staff have, again, is to move these forward for consideration to HR, Finance, and Property with the hope that we be awarded the second grant as well.
Administrator Leonard, just a quick question. Is it common practice for us to approve amending a budget if we haven't been awarded the grant?
We wouldn't amend the budget unless we were awarded. So if in January, your January board meeting, if the only grant award that comes through by that time is the one that we've already received, we would simply move that onto the county board, but you're absolutely correct. If we're not awarded a grant, we would not amend the budget. So essentially, this is a contingent recommendation on the award.
And I just want to clarify, the first award has already been, the first grant, the JAG grant has been awarded already, is that correct?
Yes, that's correct.
Okay. What is the pleasure of the committee? Any questions? Do we want to divide it into two votes? You know, first, we're just approving the JAG grant first, and then we can do the second one, a contingent upon approval of the grant? Okay.
Can we approve both of them in
We,
one motion?
we could. I don't see why not.
That would be my motion for approval.
Okay, so there's a motion by Supervisor Opal, second by Supervisor Hapa. Any other comments or questions? Hearing none, all those in favor signify by saying aye. Aye.
Aye.
Those opposed, same sign. The motion carries. Thank you. We will move on to 6A, Education Presentation Committee Discussion, 2025 Marathon County Jail Inspection Report Review. I think I'll turn this over to the jail administrator.
Jail Administrator Folden is here. This was actually his first jail inspection. I see former Jail Administrator Ledoux is in the back of the room. Previously, she had handled these. The reason that we asked that this be brought forward is because we are incredibly proud of the work that's been done in the jail, continues to be done in the jail, and we received an incredible inspection report once again for not only the cleanliness of the facility, the way the facility is run, the culture with our inmates, the culture with our staff. And we wanted that report to be available to you so that you could see that work that is being done, and then give you guys an opportunity to ask Luke any questions that you might have about how that inspection is conducted, and then what types of things they look at, or anything, quite frankly, that you might want to know about it.
Any questions from committee members? Supervisor Wilhelm.
So when they inspect the jail here, and we carry so many inmates in Marathon County, do they look at the other jails, or that's just their own county? Each county has their own individual inspection?
Yes, that's correct. The DOC has, I believe, 7 jail inspectors. The state's divided up in different regions. So each jail, including Waupaca and Taylor County, who we contract with, have their own inspections. Our inspector is aware of our housing situation and gets data on how many people are housed out.
Thank you.
I have a question.
Chair Mask.
Are inspections spontaneous, or do you know they're coming?
The annual inspection, which is what this report showcases, is planned annually. We have a variety of reportable incidents, they call it, that we have to notify our jail inspector of, and those are as the incidents occur.
Okay. And this is kind of silly, but I was reading where you have training for fires and there are fire extinguishers placed periodically throughout the jail. Are inmates trained too? Do they have, I wouldn't think they would have access to the extinguishers because it could become a weapon. How do you handle that?
That's correct. Inmates don't have access to the fire safety equipment. We have evacuation procedures in place, guided by policy. Facilities helps inspect the fire safety equipment. All that is logged and provided to the jail inspector. Pretty much we respond to different types of emergencies day in and day out and follow our procedures.
I want to say congratulations to you and the staff for having a great inspection report. Thank you for your work.
Thank you. Most of the credit goes to our staff. I'm just here to share with you. We have good leadership in the sheriff's office. My predecessor was a good mentor. Yeah, our staff do incredible work and they have an incredibly tough job, so thanks for recognizing it.
Any other questions or comments? Administrator Leonard.
Thank you, Mr. Chair. And as alluded to by the sheriff, these inspections are a big part of what happens in the jail in terms of making sure we're doing an excellent job, which our staff are doing. But this committee also has a role in that as well under Chapter 59.54, sub 15, if you're looking for some additional reading. There is a requirement that there be an inspection by the board or a subordinate body of the board of the jail. So we have that tentatively scheduled for June. The idea being that, of course, in April, there will be elections, a new board will be seated. Your first committee meeting is an orientation in May. And then in June, I think it's a sound practice to have that orientation, kind of the second level of that be that jail inspection. So this is the on paper part, and then we envision that walkthrough in June.
Thank you. Any other questions or comments? Just want to echo the comments made. Big congratulations to the team in the jail for doing an incredible job as well. So, with that said, we'll move on to B, update from Criminal Justice Coordinating Committee, Judge O'Neill.
Okay, so I am here to try and give you an update on our criminal justice issues. Haven't been here in a while. So our local criminal justice issues continue to revolve, quite frankly, around the shortage of attorneys. And I know I've echoed this message before and I sound like a broken record. For several years, as you know, we have struggled with regard to attorneys in the area. I think last year I may have reported that it's becoming clear that not only do we not have enough criminal defense attorneys in the area, we don't have enough attorneys, period. If you want to get a divorce, it's hard to find a family law attorney. We have personal injury attorneys, we have corporate attorneys, but when it comes to everyday matters of people's affairs, it's very difficult to find representation in our local area. That's now spread, quite frankly, to our district attorney's office. So historically, the difficulty has been staffing the state public defender's office locally, but also having local private bar attorneys being willing to accept criminal defense appointments. That has only intensified over the last year. But now the district attorney's office is experiencing considerable shortage. Currently, they are 4 attorneys short. Attorney Mayo is here. He graciously provided me with some information that he should be, Kyle, did you say fully staffed at 8 or? I know you're looking for 4 attorneys, right? Do you have 5?
Yes, so we're fully staffed with 13 attorneys, including the district attorney. We currently have 4 vacancies and 1 on extended military leave. So we have 8 currently, we're fully staffed at 13. So if you know any attorneys, send them my way.
So he is, I don't want to say desperate, but he really is very short-staffed, which is going to slow down prosecutions. You know, when you don't have people to review police reports and to just make prosecutorial decisions, that's going to naturally slow down the prosecution of cases, the bringing forward of cases. It's also going to slow down the case processing. I think for the first time in this county, we had to cancel court this week, right? Because there were no prosecutors available. So criminal court was scheduled and court had to be canceled. This time, not because the defendants didn't have attorneys, but because we didn't have enough prosecutors. So unfortunately, Attorney Mayo has a very difficult task ahead. He's doing a great job. We recognize in the judiciary how hard his job is right now to try to manage with the short staff, and we know that he is doing everything he can to continue to protect justice in this county, but that's just a reality. The Public Defender's Office is currently 3 attorneys short, and the problem with both Attorney Mayo and the Public Defender's Office in attempting to fill those vacancies is that there just aren't enough applicants. And attorneys in the state who are looking for employment are in a pretty good position, okay? They're in high demand. So many of them would prefer to go into private practice because obviously they're not gonna get the salary in public interest law that they might in private practice. If they are inclined to get involved in public interest law, despite the monetary consequence of that, they're choosing to stay in Milwaukee or the Madison area. And that's historically been a struggle, I know, for the Public Defender's Office, in that young attorneys want to stay in the cities. They don't want to come up to rural Wisconsin. So those are staffing issues. We continue to have the unavailability of private bar attorneys to take those appointments from the Public Defender's Office when there's a conflict of interest and they can't have a staff attorney, as well as what we call dean appointments. It's a case called where the courts determine that even though the state Public Defender's Office has deemed that an individual is now eligible for their services, the court finds that they still don't have the sufficient funds to hire an attorney, so we'll appoint at county expense, which I know you've heard me speak of before, and the county then has to cover the cost for that attorney. So that's a lot of words to just tell you that we are in a worse position this year than we were in last year with regard to the availability of attorneys to prosecute and move along criminal cases. This issue has been in Marathon County now for at least a decade. It's now expanded throughout the state, which is exacerbating the problem. And the Wisconsin Supreme Court has recognized this as a statewide issue now, and they have developed a committee to consider attorney recruitment and retention. They did release a report a couple weeks ago as to ideas on how to retain and encourage attorneys to stay in Wisconsin, come to Wisconsin. Some of those, if you may recall, our CJCC had come up with, I think we had 10 ideas back in 2022, 2023 as to how to incentivize being an attorney in Marathon County and taking appointments from the courts. Our Marathon County 10-point plan, most of them were fiscally not feasible, but we did implement some changes with regard to the appointment process, the payment process, and we were able to lure back a handful of attorneys based upon some of those small changes, but the other changes that we thought might be effective were too costly. They were cost prohibitive. The report that was released by the Wisconsin Supreme Court Committee includes really statewide initiatives, which would, some of them are to make it easier for a person who's been to law school to become a licensed attorney in Wisconsin. I don't know how in-depth you want to know about this, but you probably have heard you have to take a bar exam to become an attorney, unless you happen to go to a law school in the state of Wisconsin, which I didn't, which he did, and he did, which means they didn't have to take a bar exam, so they get the privilege. It's called diploma privilege. They don't have to take a bar exam. Otherwise, if you go to an out-of-state law school, then you have to take a bar exam. And there's something called the Uniform Bar Exam, that if you take that and you get a certain score, 42 states in the United States will accept that score, even if you took it in another state. So for example, my daughter recently took the New York bar exam. She got a score. She can not have to take another bar exam and practice in Illinois. She could move to Chicago if she wanted to stay in the big city, but she would have to take that bar exam again to be an attorney in Wisconsin. And as a mother, I'm like, this is crazy, right? I want my child to come back home, but I know she studied her little butt off to take that bar exam. She did really well on it. Why won't Wisconsin recognize her score? So that's one change that I actually had spoken to the Chief Justice about, like, we got to do something about that. There are some other thoughts on how to train attorneys a little differently. And this is all kind of far down the road, but just to give you some ideas, you know, historically you have to go to law school for 3 years, and then you take the bar exam, you become a lawyer, right? There are lots of professions where maybe you're in education for a year, and then you spend another 2 years in your profession learning, right? Not going to school. Is it possible to allow those people that maybe have been to school for a year to have a special license to handle certain type of cases? So these are some of the more creative things that we can't do as a local community, but the state is looking at. So I guess I just want to share with you that maybe there's some hope down the line. And I think I'm throwing these out because I feel like I'm such a Debbie Downer coming here today to say our position is worse than it was a year ago with regard to case processing. But with that, we are making efforts, and I will tell you that the judges in this county are constantly talking about ideas like how can we not only recruit, how can we make changes, what can we do better to make our justice system stronger and more efficient. The CJCC does have a work group entitled Case Processing, and we had met for a significant period of time for probably an 8-year period. A couple of years ago, we stopped meeting just because I think we had felt like we had made the changes we could. We didn't find any areas where we could make any more changes, hitting a dead wall. We're going to start that committee up again. Our first meeting is this Thursday to try and come up with ways that we might be able to make improvements, efficiencies, and as well as taking into account the staff shortage that the district attorney's office is facing, as well as the public defender's office. Is there some improvements we can make? Because historically, the district attorney's office has been staffed to really assign 2 prosecutors to each of our 6 branches. And is there a way that we can make our scheduling in our branches easier to accommodate now that they are down so many attorneys, and you're going to have these attorneys that instead of covering 1 branch, they're expected now to cover probably 6, Kyle. I don't know if they're expected to go to all 6, but they're expected to go to multiple branches now, which is really difficult for them. So are there ways that we can change our scheduling process to help them and assist them? Another thing that slows down our courts, which you're all aware of, is defendants, first of all, not having attorneys, but then once they have an attorney, if they fail to appear for court. And I know that's been a concern, and I don't know, Supervisor Hoppe, if you were the one that emailed Lance, but I know somebody on the committee had a question with regard to our bond forfeiture practice. So I'd like to address that a little bit here today. So as you know, when a defendant is arrested or summoned into court at their initial appearance, generally the court will set bond. It can be on their own recognizance. They don't have to sign a bond. It can be a signature bond where they're promising an amount of money. If they fail to comply with the conditions of bond, they don't have to post the bail, the money. They sign a signature bond. Alternatively, there can be a cash bail component to the bond where they have to post the cash in order to maintain their community base without having to be in jail. There are conditions of bond. The number 1 condition of bond, the rule of bond, is that you come to court when you're required to come to court. A lot of times people don't come to court. So the question is how to best address that. And we have tried to do that through our pretrial supervision program, right? We have that as one tool to try to keep people on course, trying to provide them with supervision, services while they're on bond, text message reminders that your hearing is coming up, you need to be in court, don't miss court. And there are still those that fail to appear for court. Marathon County, so the statute does provide that courts have the authority to forfeit a person's bond, so that if they violate a condition of bond, including failing to appear for court, the court can forfeit that bond. They can forfeit the cash if it's been posted. They can forfeit the amount of signature that was promised. So even if they don't have to post the bail, if they sign a $500 signature bond, if they fail to appear in court, the court can forfeit that bond amount. So in Marathon County, we do have a process, which I think was developed about 10 years ago. Well, no, longer than that. I want to say around 2010, actually. The county came up with a bond forfeiture process, which has been tweaked over the years. But in general, the process does comply with section 969.13 of the Wisconsin state statutes that does give courts the authority to forfeit bond. And that statute does provide that the court can, within its discretion, forfeit the bond. But once the bond is forfeited, then the defendant has to be given an opportunity out about 30 days to come into court to explain why they failed to appear for court or why they failed to comply with the condition of the bond. And it's at that hearing that the court then determines whether or not it's in, if justice requires the enforcement of that forfeiture. So even though the bond is forfeited at the first hearing, then there's a second hearing where the court determines and uses its discretion. Is this a case in which justice really requires the entering of a judgment in that monetary amount? So in Marathon County, when a person misses court without an excuse, the court will generally authorize a warrant for their arrest and forfeit bond and schedule a bond forfeiture hearing about 30 days out. The defendant is sent notice of that bond forfeiture hearing. And at the bond forfeiture hearing, if the defendant does not appear, the bond is automatically forfeited. Judgment is entered in that monetary amount. If the defendant appears, they're given the opportunity to explain why they failed to appear for court. There are occasions where the defendant was in custody in another county and they can establish that. There are occasions when the defendant was in the hospital or sick. There are occasions where a defendant may say, they lost a loved one, they were at a funeral. Oftentimes it might be transportation issues. There are lots of reasons people give, right, for missing court. And it's up to the court to determine whether or not justice requires the enforcement of that forfeiture. And the courts have broad discretion with regard to that. There's no set rule. Things that the courts do consider really is the expense caused by the defendant's failure. Where we're at in the proceeding. If they fail to appear for a jury trial when we have jurors here, obviously the cost is extraordinary. If they fail to appear for a simple pretrial conference, the cost really is minimal. The stage at the proceeding too. And maybe their history. Have they missed court before? How long has this been going on? There have been occasions where a person, there are times where a person is on a deferred entry judgment agreement and there's a review set out a year, sometimes 3 years later. Well, if they fail to appear for court 3 years after they receive notice, most people are going to get a second chance. We're going to reschedule it and see if they show up next time, if they don't. So there are lots of things, as well as the severity of the offense. I don't think I mentioned that. If it's an offense for which the public really, we fear for the public safety, that this person's out of custody and they don't appear for court, it's going to be treated a little differently than if a person is out because they were driving without a valid driver's license. So there are lots of factors that the court does take into account, but ultimately it is the judge's discretion then to determine whether or not justice requires entering judgment for that money amount. Additional things that can occur when a person misses court, obviously that bench warrant is issued. The district attorney's office can consider filing bail jumping charges, but quite frankly, that's not always the most efficient, right? Because then we have a new charge, we have to get a prosecutor to prosecute it maybe, an attorney to defend it. If it's a felony offense, they have to have a preliminary hearing. So that can be an expensive way to address the issue as well. We can increase their supervision level, their pretrial supervision level, and or increase the bond amount, the bail amount. So there are ways that we do attempt to incentivize court appearances, but that is how our bond forfeiture process works with regard to what our policy is. That's how we do it. So Supervisor Hoppe, do you have any specific questions with regard, I know that was one of your concerns with regard to the bond forfeiture process?
My thing was when they don't show. And I know this would be very difficult to calculate, but I think that there should be a fine, not necessarily in the first one, but if they reschedule and they don't show for that, it's a fine. If they don't show for that, there's an additional fine. There has to be something there that makes them say, I better take it seriously. Because if they cancel and they don't show and nothing happens, we're the losers. Definitely we are the losers.
Sure.
But
Yeah,
we
we
have
don't
to-
necessarily have, we don't have the authority to impose a fine. Well, we have the authority to forfeit the bond, which we do. So if they fail to appear, we do give them that opportunity to come and explain themselves. But I have to say, many people, if they've missed the first time, they miss the bond forfeiture, and then the bond is automatically forfeited. Now, if it's cash, they lose that money. So if it's $500 cash, they lose that money. If it's a $500 signature bond, it becomes a judgment that is entered at the clerk of court's office through Department of Administration or Revenue, and they will ultimately lose their tax refund or whatever. So there is a monetary loss when their bond is forfeited. But we can't impose a separate fine. So the only
Right.
thing we can do is forfeit that amount of money.
And I understand that. But there has to be a way for us to recoup the cost of the court reporter and the bailiff and anybody else that shows up there to hear them and then they don't show. I mean, it's not like the county can take their salary away. They haven't done anything. I mean, they're there and nobody's there. But whoever is the offender, there has to be a way that they're going to end up paying a price for it.
And so that's the process we have, is we forfeit their bonds.
So that would be included in that.
I just want to remind committee members to direct comments to the chair as well too, so that I can control, make sure how everything's going as well. But I know the administrator Leonard wants to add, provide in some insight as well.
Not so much on the bond stuff. So if there's any more questions specifically on bond, the bond forfeiture process, and not only the forfeiture, but then I think to your last point, Supervisor Hoppe, the thing that happens if people don't show up, as Judge O'Neill referenced, if they miss a hearing, miss a bond forfeiture hearing, and they have the history of missing, being afforded bond is not a well, it is a requirement in the state of Wisconsin, but you can get a bond you can't post. And then you get very well acquainted with Administrator Volden and his very skilled staff that you just heard about before. Because if someone gets a $10,000 cash bond and they can't post $10,000, they sit while their case is pending, which poses different problems. But I wanted to go back to the attorney shortage, but I don't want to, you guys ask your questions on the bond stuff.
Supervisor Wilhelm, go ahead.
Some of it kind of relates to the shortage, but I do have one question about, now, if I look at the WASA pilot review and I see what people are being arrested for, bail jumping is added on there quite often. So how many people are actually not showing up to court?
So the bail jumping charges, is Kyle still here? More often than not are related to breaking a rule of the bond, such as no contact. So if there's an act of domestic violence or a victim of any sort, right, in a crime, a condition of the bond will be that you not have contact with the person you're alleged to have assaulted. So usually they're violating that no contact. Another rule of bond often is that you not consume or possess alcohol. A lot of times they're breaking that rule, and then they're gonna get a bail jumping charge. Kyle can speak to it, but I don't know that bail jumping is all that often charged when they miss court. The bail jumpings are because they've broken a rule.
DA Mayo.
Yeah, generally, for bail jumpings, it's violation of the no new crimes also. So that's a condition on every single bond is not to commit any new crime. So if you are out on a bond and you commit a new crime, that's gonna be a bail jumping. So that's a lot where you see it's attached because there's a new crime, then that's a bail jumping because they violated that condition. We generally, unless it's a special circumstance, aren't filing on missing court. We're relying on the bond forfeiture process for those just because there would be, it would just keep adding up the cases then.
Any follow-up, Supervisor Wilhelm?
Yes, and.
Go ahead,
so-
Supervisor Wilhelm.
So what is the percentage of people that don't show up to court? Does anybody know?
Administrator Leonard?
I don't know, I can get you that answer. We have, one of the areas of data that we collect is, as Judge O'Neill referenced, we have a pretrial supervision program. So essentially if Lance gets charged with a crime and is held in custody and shows up to court, there's a process by which I'm assessed by a pretrial assessor to try to look at my likelihood to do two things. One, the most important thing, right? Show up for court, and a close second, and I'll say 1B. 1A and 1B is, hey, commit no new crimes. So trying to assess my likelihood to reappear in court, I get assessed, I get a score, I get put on a metric, and I get, for sure, I'm gonna get text message reminders, and I can get some other things. And we do track appearance rate by those various, I think is it 1 through 4 or 1 through 5, Laura? Yeah.
We don't provide any supervision other than text reminders.
Laura, can you speak into the microphone, please?
Yeah.
Yeah, there are 4 levels. We don't provide any actual case management supervision to the level 1s. Those are the most low-risk individuals. Everybody gets text reminder phone call or to their phones. One thing I will point out is that we have a really hard time keeping working phone numbers for people. So that's another part of it. We also have a large number of people who are unhoused, and it's difficult to get their mail, so, and get a hold of them. But some of the people who score at a level 4 that are released into the community actually receive weekly case management appointments and all sorts of other services. So there's different levels of supervision based on their needs and risks.
So we can report back on the likelihood of appearance or our appearance rates at a future meeting. That's actually one thing where Michael and Laura and our justice system provider have worked a lot on.
Yeah, we do have that on our dashboard. I think I've presented that very long meeting where we went kind of quickly over all of them, but we do break it out too by level so that we're verifying that our tool is accurately predicting for those 2 measures.
Supervisor Wilhelm?
The only reason why I ask is if you can see the number of people that are missing and you can calculate out how much it costs per hour for that person to be on trial, you can see what the cost is of people not showing up to court.
For sure. And I think, that's one of the things, I think it was either Supervisor Hopper or another board member had reached out previously. And what is the cost of someone not showing up for court? Whether you talk about, there's the judge, there's the court reporter, there's the judicial assistant, the prosecutor, is there a defense attorney? And my lawyer answer is, well, it depends. How do you measure cost? A lot of those positions are state-funded positions. So Judge O'Neill, that doesn't mean it's not taxpayer funded, make very clear. A lot of it is taxpayer money. But on the county budget side, it really depends on kind of the nature of that case. But we can certainly bring back the appearance rate, the appearance piece. I think the thing I wanted to get to, and I don't want to shut down questions, but just to foreshadow, is the delays in the processing of cases. The longer, this makes logical sense, right? The longer you string a case out, regardless of reason, the likelihood of someone failing to show up, or given the population we're dealing with, that they pick up, as DA Mayo said, a new charge, or they violate a condition of bond, all those things go up, which that then only further lengthens out how long cases are pending. So to Judge O'Neill's point about getting the case processing group back up and meeting, I think is a good thing. But I do think, as I'll talk in a little bit after your questions more about the bond forfeiture, we might be to a point where the county, we're not well served to wait for the state of Wisconsin to solve our problems about attorney shortage. We've done that. We've asked the state. I mean, I've served on a committee for the state bar where I've served on a number of their committees, their continuing education committee, their bench and bar committee I still serve on. I was on their finance committee. This has been an issue for the last, like Judge O'Neill said, for a decade, but I'll get to that in a minute. Any more bond forfeiture questions, I'll let.
Any additional questions?
Let's go.
Could we turn the floor back to you, Administrator?
Sure, thank you. So just to add context, if you have a bunch of time and you want some good reading, that report from the Supreme Court is 21 pages long. The State Bar of Wisconsin has put out similar reports on attorney shortages. To put things in context, it's 3 districts in the state of Wisconsin, which really are just, to the judge's point, Milwaukee and Madison. 73% of lawyers in the state of Wisconsin are in those districts. That's less than, when you then look at the population of the state, less than half of the state is in those districts. So there are just not enough lawyers in other parts of the state. It's imbalanced. Since 2017, the number of lawyers in the state has gone down by 10%. And that does slow down divorces and all sorts of other things, civil cases. But more context, the problem is more acute on the criminal justice side. During that same 10-year period, the number of felony dispositions in the state of Wisconsin went up by 14%. So when you consider that the state public defender's office is charged with representing indigent individuals, we rely upon dean appointments. Those are the county fronts the money essentially for the defense attorney when they're not quite eligible for public defender, but they also don't have enough money to get their own private lawyer. Felony cases are a big part of the business of the public defender's office and others. And those are the things that can slow the justice system down because those are the things, if you're gonna be held in jail, far more likely on a felony or a series of felonies than it would be perhaps on a misdemeanor. And then when you look at the DA's office, the number of felony charges are all coming through the DA's office. There's not a private prosecution arm in the state. So there are a lot of pressures. You think about the demographic shifts that we talk about in terms of general population in the state of Wisconsin. People are moving to the more urban counties, more urban cities. Not only that, but we have lawyers are not coming into the profession at the same rate that they're retiring. We talked a lot about the district attorney's office, public defenders, and private bar. Another lawyer in the room. You had quite a few lawyers in the room. Brian's got a vacancy in the corporation counsel's office right now. A lawyer position. So it's a challenging area. In fact, I've been talking with the Greater Wausau Prosperity Partnership about, we made a presentation to the Extension Education Economic Development Committee about trying to get a worker relocation program, apply for a grant where the county's not going to apply. The Greater Wausau Prosperity Partnership is going to apply. The committee recommended that the county sign a letter of support for that application. targeting certain industries. And in our area, one of the industries that is really hard is lawyers. We're not unique in that. Again, unless you're in Milwaukee or Madison, your answer, if someone asks, do you have enough? The answer really is no. So delays, whether it's because there's not enough court time, if the judges are too busy and you can't get in to resolve your case, whether it's because you can't get a defense attorney, because there's not enough public defenders, I'm eligible, but I'm waiting and they can't get someone appointed, or they can't get a private bar lawyer appointed, or now the challenge we have with the district attorney's office, there's not enough, your prosecutor's not available. All of those things are bad because they lengthen out the time it takes to resolve a case. I, as a defendant, am more likely to miss a court date. I'm more likely to not comply with some aspect of bond, and then it's just going to further challenge the justice system. So the county's done a lot of things. I want to end on some positive notes before we talk about kind of what do you guys want to look at for next steps. But the county has funded a lot of innovative justice system things, whether it's dealing with cases through deflection, diversion, those programs within the DA's office, whether it's our pretrial program to try to provide some level of supervision so people show up. You also fund a mediation program, not a criminal justice thing. Working with Judicare would mediate disputes between landlords and tenants who are being evicted to free up judge time so that the judges can do the criminal justice stuff, because that is more valuable to the, it's all valuable, but on the county budget side, that hits the pocketbook, as you were all alluding to before. So you funded all of those things. But there's still this lingering challenge. And that white paper, there was a presentation, Judge O'Neill made it a couple years ago to this committee saying, hey, here are some things we could do. And the process stuff about how we make appointments was changed, how we pay lawyers. One of the things we heard was, hey, if I do the work, I want to get paid, not, if the case takes 6 months to close, I don't want to wait till month 8 to get paid. Makes sense. Interim payments. So we did a lot of things. Probably makes sense for us to sit down and say, hey, what else could we do? Other counties are doing something that I will never, I shouldn't say never, but I can't say I will endorse at this point, which is for those dean appointments, they're paying more than what is required. I don't think that helps, because all that's going to do is, if I'm a lawyer, I'll say, I'll take your dean appointments, but I won't take your public defender appointments. So that'll just slow the justice system down a different way. It's kind of like a balloon. You squeeze it, it's not like it gets smaller, it just bulges somewhere else. So how do we be really intentional about it? There are not enough, and we're talking right now about lawyers. Kelly Schremp, the clerk of court, I mean, they've had turnover in those positions too. Doesn't mean, like, if you don't have a judge, court doesn't happen, but also it doesn't happen really well without a court reporter or a judicial assistant to schedule it, or a court clerk to clerk it. So you got to have everything for court to move forward, and it's a challenge. Staffing is a challenge. Knock on wood, I think we're in a lot better position than some of our peers, but still a challenge.
Supervisor Wilhelm.
Now, as somebody becoming a lawyer, I can imagine what student loans are racking up to when you go to college and 3 years of law school. Now, when somebody comes in to be a prosecutor in Marathon County, are they making enough to live and pay their student loans, or is it kind of, I don't know what they get paid, so I'm just curious if there's a reason in that too.
Kyle stepped out. I will tell you, so from lived experience, and I was a long time ago for me. Yeah, law school's not getting any less expensive. I think it's certainly a challenge. People leave public employment. Oftentimes, I think on our presentation to HR Finance, 72% of our exit interview data was, why are you leaving? I can make more money elsewhere. I know we had a lawyer, very good lawyer in Brian's office, that left to take a position in the private sector, essentially double 100% raise, not counting any other extra like bonuses that you get in the private sector, which this might surprise you, we don't have those. We don't have profit sharing at the end of the year here. So short answer, yes, it's certainly a challenge. One of the nice things that I think we can do better to market is if you do get involved in work for a governmental entity, at least right now, there's the prospect for loan forgiveness. It takes 10 years though to get it. And you have to be making payments the entire time. So short answer, yes. I don't know, Judge O'Neill, Brian, feel free to jump in too if you want.
I would just echo that I think what keeps them in, what keeps public interest lawyers, at least in our area, in, is loan forgiveness. And you will see at the 10-year mark, a lot of times they then leave because they've finally gotten their loans forgiven. But that's, I think, what keeps them in. They have, I think the salary is good enough to live in our community as long as they're getting loan forgiveness, because in that process, they only have to pay a minimal amount toward their loans during that time. So that's how they can afford it.
I would just add though, I mean, the costs of everything else, which every other human being living in the county knows, I mean, when those things all got more expensive, I think it got harder to
And I will agree, so I'll just share with you my personal experience. I'm not local, right? Okay, I was born and raised in the Chicago area, went to law school in the Chicago area, that's why I had to take a bar exam. I came up here because it's beautiful and we vacationed up here and I never regretted it. I've been up here now 30 years, love it. But when I chose to come here, I was offered a position with the Wisconsin State Public Defender's Office, making $32,000 a year. I was offered a position with the state attorney's office in Cook County, Illinois, would had to live in Chicago, right? For $26,000 a year. So at the time that I came to Wisconsin, it was a windfall. I, over my 30-year career, have watched my peers in every other state getting raises and me flatlining. So there has been a huge flip. So in the 90s, in the 1990s, when I came to this community, this was the state, this in Minnesota, if you wanted public interest law, come to Wisconsin, go to Minnesota. Don't stay in Illinois. Don't go to Michigan. God, don't go to Iowa or Indiana. Wisconsin and Minnesota was the place to be, but it's really changed over the last few decades.
Supervisor Harper.
This is just
Can you use your microphone? Thank you.
It's an idea from my past life. Has the state or the county thought about creating a program like the military has, where we will pay for your education, but you got to come back here and do your time after you graduate. And you're guaranteed to have lawyers. Then you hope they enjoy the area and stay. But you can get 4 to 6 or more years out of somebody by doing that. But I don't know how scholarships work and who would fund it, whatever. But that would be a thought to if they're interested in law at all, it's like bringing them in through the back door, so to say.
Administrator Leonard.
Yeah, I mean, we've had conversations, not so much with law school about that, but I mean, we have an education reimbursement program for the county if you work with us and, hey, to progress in your career, want to go back to, go to college or get a tech certificate or even a master's degree, we'll pay for a portion of that with the understanding you do what you said. I haven't heard of any programs specifically targeting public interest. I will say the law schools, when I went, just a little bit after Judge O'Neill. But when I graduated, when I was going through law school, I went to Marquette, one of those state schools where you got out of taking a bar exam. And I worked for the State Public Defender's Office as an intern. I interned in the Milwaukee District Attorney's Office. And those were full I mean, that internship in the DA's office was big. I mean, there was 20-plus law students that participated. The same was true with, I understand Wisconsin, the University of Wisconsin Law School had that program, and they would do a summer internship, and we used to get summer interns come up to Marathon County and be an intern for a bit. I don't know when the last time we've had those programs have shrunk. I think some of that is, as Judge O'Neill said, the attractiveness of government law jobs, lawyer jobs, has not kept pace with how attractive a private sector law job can be. So short answer, no. I mean, we haven't looked at that. I think it makes it, again, it's not an impossible task, but it's just, Wisconsin's interesting with, all the prosecutors in Kyle's office, they're state employees. The public defender's office are state employees. And of course, the private lawyers that are taking dean appointments are private lawyers. It's what are some things we can do on the margins, I think are interesting. Again, I know I've been working with the State Bar for a great many years talking about what to do. And the State Bar has advocated a lot for public defender's office, prosecutors, and for getting lawyers into the rural areas. The increased pay for prosecutors and public defenders over the last couple of budgets has helped, but it's still hard.
Administrator Leonard, you mentioned that there's going to be, that we probably should start looking to developing some sort of initiative that would be focusing on Marathon County, whether it's a task force or something along that lines. What are we expecting for the next steps here then?
I didn't have any expectations of next steps. It was just I knew this was going to come up in the judge's comments, and I think it's important for you guys to hear. And then if you have thoughts on, hey, what can we do? We can look into it. I mean, one of the things we toyed with was, and if you are, again, looking for more reading, there's a great article in one of the most recent Wisconsin lawyer magazines about trying to help lawyers from those other districts that I talked about, Milwaukee, Madison, get them comfortable to relocate here and even open their own law office, because that's a big undertaking. Particularly for a young lawyer who doesn't have 10 years of experience, you might not feel comfortable doing that. They did a whole series and they offer a lot of education on how to get comfortable and how to make that work. We talked about having office space. Is that something we can offer in a county building, lease out office space? Now there's a whole procurement side there, but I'm a big fan of outside the box thinking, even though maybe a lot of the outside the box stuff we are legally prohibited from doing, or there's a good reason not to do it. But I don't see this problem getting better without something happening. Right now, we're catching up to the bad that other counties have felt for a while.
Chair Mask?
Oh, thank you. When I worked at the hospital, our family practice residents that came in, they did a 3-year program here. And I believe it was the federal government that did forgiveness for some of their loans, if not all. If they went to another place to practice, usually a place that had lack of medical and doctor care, and they would probably have to serve there for 2 or 3 years. But maybe the state or the federal government should start looking at something like that and start making these professions a little bit more attractive. I know it helped with our residents. I remember one couple that put their time in on an Indian reservation and came back to Wausau.
Yeah, the federal government does have student loan forgiveness for prosecutors and for state public defender's office employees. I will say one thing that Marathon County has done, I mean, it did it when I worked in the DA's office. A nice little incentive is bar dues for the state of Wisconsin are in excess of $500. Private law firms, as far as I have yet to meet a private lawyer who doesn't have their bar dues paid for by their firm. I've met a lot of counties, a lot of prosecutors in other counties who have to pay their own bar dues out of their pocket. Marathon County for a long time has, you have a law license to do your job here, we'll pay for your license fee. So that's a little incentive, but I think we're gonna have to keep looking for other ways to do that.
Any other comments? Supervisor Sandowski.
Thank you, Chairman. I just got a question for the relation to the bar exams. What's the difference, like you're saying, from state to state? Is there quite a bit of difference?
So the universal bar exam, okay, is really just like what everybody learns in law school, right? And generally, states have that. And then on the second day, they'll have a more state-specific bar exam. And so what these 42 states do is they will accept your score because they know that you've taken this multi-state bar exam that covers like all the basics and you've done well. As far as Wisconsin's bar exam, they have the multi-state and then they have a separate state on the second day. And they just don't recognize that multi-state score that you might have gotten. So like my daughter in New York. State laws certainly vary throughout every state, but the federal Constitution, right, the United States Constitution, that is something we all learn in law school. And that sets forth most state constitutions as well. So much of state law is the same from state to state. We call things a little differently. We have different numbering systems, but generally most states are the same, with a couple of exceptions. And I understand this. So just, now I'm probably going on too long. But my daughter went to law school in Louisiana. She loves Louisiana. Louisiana is based on French law. Every other state is based on Britain law, right? English law. So she did take the Louisiana bar exam, and it is really different. It's a week long. It's like all essay. I get that. It's like, because their laws, she was telling me some of their laws, I was like, that cannot be a law. And for sure enough, it's a law. It's just kind of crazy. I understand, like, they're very different. You might want to have a separate bar exam. But for like between Wisconsin, Illinois, Michigan, Minnesota, like our laws are pretty similar. So that's why they've, in the last probably decade, they've gone to this universal bar exam where you can take one if your score is high enough, depending on your state. And I don't know if that answered your question, but all in all, most state laws are very similar to other states. California is another state which is a little wacky. They have their own bar exam. I can respect that because their laws are a little different as well. Massachusetts is a little different too, but otherwise all the other states are pretty similar.
But we don't, the Wisconsin don't accept, you said?
Right,
I mean,
no, so you have to take a bar exam here in Wisconsin unless you went to a Wisconsin law school. Or there is another avenue. If you've practiced law for 5 years in another state, you've been licensed in another state practicing law for 5 years, there's a way you can become licensed based upon the recommendations of judges in your jurisdiction, and you have to do a whole application with regard to your character and fitness and that sort of stuff. So you wouldn't have to take the bar exam, but you have to have practiced in a state that Wisconsin basically partners with for 5 years.
Would it help to, like, for counties to do resolutions to the state to try to get the state to, you know what I'm saying? To try,
Sure.
if you get enough counties together.
It might. I can investigate a little bit where the Supreme Court is on changing that to adopt the universal bar. And so I can come back to the county board if that's something that you'd be willing to do. It might be helpful. So thanks for the idea.
Thank you.
Chair Zhang?
Yes, go ahead, Chair Mask.
Exactly what I was going to say, Tim. What can the county do to help encourage Wisconsin to change this so that we have a uniform situation for lawyers? So good suggestion. I totally agree with that.
Any other comments or questions from committee members? Hearing none, thank you, Judge O'Neill, for your time.
Thank you. And before I leave, I just want to say one thing. I know I've taken up all your time. But I want to recognize what the county board has done with regard to the compensation plan for the employees, because as Administrator Leonard noted, the courts don't operate with just state employees. I have a county clerk and I have a judicial assistant, and they are two of the most talented people I know. And quite frankly, in my opinion, they're underemployed and they're underpaid. And you could see that they were disheartened. And a couple of weeks ago, there was a smile on their face. And my clerk, who's very young, shared with me that she was getting a nice raise based upon this. She's expecting her first child, and she's just suddenly ecstatic. She's so much happier, and I just want to thank you for valuing them and recognizing them, because they work way harder than I ever have, and they deserve it. So thank you for what you've done for the county employees. With that, I'm sure you thought you were having a short meeting. I'm sorry, but
Thank
I
you.
appreciate your hearing me out. Have a great day, everybody.
Thank you. We'll move on to Marathon County 2026 Comprehensive Plan Draft available for review. Who's the staff that's? Okay, I'll turn the floor over to the CPZ director and Jeff as well.
Thank you, Vice Chair. So in your packet, beginning on page 8, there is a memo and a summary document of all the goals and objectives in the draft plan. The Executive Committee has completed a full draft of the 2026 Comprehensive Plan, and where they're at right now in the process is they're putting it back to the standing committees to take one more look at that plan and give them any feedback or suggestions prior to their meeting in February. So they're asking for suggestions by February 11th, 2026. The document, or in your agenda and in the memo, there is a link to the full comprehensive plan that you can review, of course. But again, in your packet, we have created a summary of all the goals and objectives that are in the plan, because those are where we would really like to concentrate people's review. Those goals and objectives are what become part of your next strategic plan that you'll work on in the next session of county board. So we really encourage people to take a look at that, and for the Public Safety Committee to really focus on looking at Chapter 7, since that is the public safety chapter. A couple things that have come up at other standing committee meetings last week was just the reminder that the goals and objectives, the goals are definitely what the county is aspiring to be, and those objectives are providing a little bit more guidance and direction in how the county is proposing to achieve those goals, but they might not have every specific item or thing that the county wants to work on. Within Chapter 13 of the comprehensive plan, if you want to review that chapter as well, you'll see that the goals and objectives are restated there as well, along with a set of action items or strategies that would accompany those goals and objectives. So an example that came up at Health and Human Services was that in Chapter 4, there isn't a specific objective laid out related to homelessness, but in reviewing Chapter 13, if you look at the strategies and actions that are accompanying those goals and objectives, you will see would that provide a variety of safe and affordable housing options that meet the needs of all community members. There are some strategies related to homelessness. So I think that's just a couple of things we wanted to remind people of, is definitely take a look at those goals and objectives, understand that the objectives are still meant to be broad, and that there are action items and strategies associated with those in Chapter 13 that you can review as well for a little bit more direction. I'll let Administrator Leonard add anything else he would like to add at this point.
Administrator Leonard.
Nope, well said. I look to the strategies. If you're thinking something's not in there, you might be right. But take a look at the strategy section as well, because we might have already, I shouldn't say we, you, previous boards might have already thought about those things and included strategies underneath the objectives. The objectives are very, to Lori's point, very broad. And one of your objectives is ensure every child makes it to adulthood with health, stability, and growth opportunities. You have a lot of strategies that kind of narrow that. So, thanks, Lori.
Any comments or questions from committee members? All right, hearing none. Thank you, Lori. We'll move on to 7, next meeting date and time, announcements and future agenda items. Committee members are asked to bring ideas for future discussions. The next meeting date is Tuesday, February 10th, 2026 at 1:30 PM in this room here. I will now move on to number 8 and entertain a motion to adjourn. Is there a motion to adjourn? Motion from Supervisor Opal, second. Second from Supervisor Hopper. Any discussions? Hearing none. All those in favor signify by saying aye. Aye. Those opposed, same sign. The motion carries, and we are adjourned at 2:40. Thank you, everyone.